But two cases before India's highest courts today have raised some questions about what the judiciary is actually taking up. First up, the Gujarat High Court issued notices to the developers of Pokemon Go, the central government as well as the state government. This after a petitioner alleged that the game is disrespectful to Hindus and Jains. His rationale, well, Pokemon Go allows people to capture eggs inside temples, which is, according to the petitioner, outrageous. What's more, he even argued that Pokemon Go is a secret CIA project by the United States to spy on the world. Now, the second case is that of musician Vishal Dadlani. His tweet on the Jain monk who spoke at the Haryana State Assembly created a controversy. Since then, Dadlani, who supports the Aam Aadmi Party, has deleted that tweet. He has said that he has nothing to do with politics anymore. The monk has forgiven him, but cases against him are piling up, and today the Supreme Court has refused to give him any protection. Joining me now to discuss both these cases is the senior Supreme Court lawyer, Sanjay Hegde. Mr. Hegde, appreciate you joining us here on CNBC TV 18. Let me start with the first one, and that has to do with this, seemingly bizarre petition against Pokemon Go, accusing it of being disrespectful, hurting religious sentiments, and so on and so forth. I mean, there is near unanimity within the judiciary to dissuade frivolous litigation, and yet we have the Gujarat High Court actually issuing notices on this petition.
Well, sometimes, when petitioners are not very clear, judges often want to hear the other side to try and make out whether the petitioner has a case. I quite suspect that this is one of those cases of that kind. While Pokemon Go might be absolutely the in thing for a lot of young India, I'm not sure that too many judges exactly know what Pokemon Go is about. Eggs, religion, temples, maybe those were the buzzwords that hit the court. They probably saw
but Mr. Hegde,
maybe
should the
there
court
was some
really
case
be
of
going
offense.
by buzzwords?
They wanted to get more details. Just 1 minute. I don't think there's any judicial determination as yet in issuing a notice. A notice is basically just calling the other side and say, tell me what this is all about.
No, I understand that, sir, but the fact of the matter is that on one hand, you have the Chief Justice complaining about pendency, you have the Chief Justice crying about how the courts are having to suffer backlogs, and then, you have a situation where petitions like, should Pokemon Go be treated as being disrespectful, what is the message then that the court is sending out?
Well, I don't think the court intended to send out any message, and I don't think too much of a message should be read into it, except the fact that courts are often manned by people who are technologically challenged, because quite frankly, the higher constitutional courts are full of people who are nearing the age of 60. It happens. I know about Pokemon Go because I have teenage sons. But it is quite possible that there is a generation for whom Pokemon Go is entirely alien. The idea that there are virtual eggs that can be kept in real places may be a bit hard for them to immediately grasp at first blush. I'm sure that when they are informed about what the facts are by either the Union of India or anyone else who's been summoned, they will drop the proceedings.
Okay, let me also bring in Kamini, Jaiswal. I have to confess that I don't understand too much about Pokemon Go either. So, I'm also on the tech challenge side. But Kamini, Jaiswal, I want to talk to you about the other case, and that has to do with the matter related to Vishal Dadlani. Now, he put out a tweet. He has since deleted that tweet. He has then apologized for putting out what may have been seen as an offensive tweet. He approached the Supreme Court seeking protection. Today, the Supreme Court says that, sorry, we cannot grant you protection. What do you make of the manner in which this has transpired?
Are you talking to me? Hello?
Yes, Ms. Jaiswal.
Now, first of all, I would like to really clarify what Mr. Hegde said. It's really, I think it's bizarre, that notice in the Pokemon case. And to say because judges are above 60, they don't understand, I'm sorry. We are in the age of e-court, and they are judges. I mean, we will be surprised as to how much the judges also know. Maybe they don't have children, teenage, but I'm sure they have grandchildren. So therefore, to say that they don't understand, and so this is only another extension of the intolerance. Gujarat wants to show how intolerant they are. That's all. I think it's completely absurd, that notice that has gone there. And these kind of cases are bringing a bad name to public interest litigation. These kind of cases are wasting court time and increasing the, pendency in the courts. Number two, Vishal Dadlani. Again, that is another level of intolerance. Now, what is wrong with us? Can't we deal with better legal issues, national issues and other issues relating to right to liberty, human life and security and other things? What are we talking of? Somebody makes a, something on tweet or something on Facebook, can we go wild? What's wrong with us? I think they're just unnecessarily wasting time. And this is also because courts are not coming down heavily on such. I'm glad, one of the judges in the Supreme Court has at least said that, you can't have sedition and laws like this and defamation for such. But, we really need to get our heads in order.
You're absolutely right. Justice Mishra, in a recent Supreme Court judgment, has said very clearly that making a strong criticism of the government is not even defamatory, let alone seditious. But, you were talking about the courts coming down hard on seemingly frivolous litigation, Ms. Jaiswal, and I'll get Mr. Hegde also to respond to that. You had a 2011 judgment of the Supreme Court which had recommended augmenting the ceiling, to at least 1 lakh rupees. The Supreme Court had then argued that the unrealistic penalties of 3,000 were not discouraging frivolous litigation. What should be done at this point in time so that we don't end up in a situation where people are petitioning or using the PIL route for Pokemon? Ms. Jaiswal?
Well,
yeah. No, I think, really you should impose heavy penalty on such things. First of all, you should throw them out of the window. Completely. Don't even... This is crazy. I mean, what religious at least if the judges don't understand, the person who came to court at least understands what Pokemon is. A person who comes to court and knows what he is doing is frivolous, and if he does it, he should be held responsible and penal consequences must follow. Judges may not understand, but at least the fellow who came, he knew what he is doing. It's complete frivolous, waste of court time, and completely publicity interest litigation. I mean, you won't be discussing that man if he hadn't done this Pokemon.
You're absolutely right on that front. Mr. Hegde, how do we ensure that we come down, or the courts come down, on frivolous litigation?
Well, the point is that litigation which looks frivolous to a lot of us may be very serious to the man who brings it to court. So the point is, if he is serious about it, he must be made to pay in the event that he is wrong. One way, of course, is to maybe penalize a lawyer who repeatedly comes with frivolous public interest litigation. We lawyers also protect each other. But I've seen some lawyers who are specifically only in public interest litigation. They take a first filer advantage, but they bring nothing of value to the table. The party themselves, you should heavily fine them, and costs should be actual costs. For instance, in that Pokemon litigation, I'm sure that that corporation somewhere from San Francisco will consult its American lawyers, consult its Indian lawyers, and then put up a senior advocate to defend it the next time. All those actual costs incurred, if the petitioner who brought it to court was actually asked to pay for it in the event of his matter failing, then that would be deterrence. But there is one question. In fact, judges should be more vigilant. You see, the instinct of a judge sometimes when he doesn't understand a matter is to issue notice and ask the other side to come out and help. It may just be that when a matter looks complicated or it looks beyond technical competence, it may be better to adjourn the matter and then take it up on another day after having read about it. In the era of Google, you know, ignorance of fact cannot really be pleaded all the time.
Yeah, that's the point that Kamini Jaiswal is making as well. Ms. Jaiswal, before I end this discussion, and we've got just about a minute, you know, what more can be done if we were to look beyond costs? Because we have seen what other countries like the UK, the US, etc. are doing to discourage vexatious litigants. Beyond just penalties and costs, what else can be done to come down hard on frivolous litigants?
You know, to begin with, I think let us confine ourselves to penalties because we don't know what judges will do tomorrow. Let us, let us be fair. The person, and if this fellow who came out with Pokemon, if he's not able to explain his case to the judges and the judges are not able to understand, that is all the more reason that the matter should have been dismissed at the outset and not, impose cost on anybody, impose cost on him, whatever, you may feel, and why trouble the, corporation in San Francisco to come here and do all this? What a lot of waste of time, what a lot of waste of energy. What a lot of waste of everything. If the lawyer was not able to explain his point of view and the judges were not able to understand, then all the more reason the matter should have been thrown out. They should understand that it raises a substantial question, or they should understand that it raises some issue. Only then they should issue notice. They can't issue notice because they don't understand.
You're absolutely right, and we hope that, as you said, judges will be more vigilant. Mr. Hegde, Kamini Jaiswal, appreciate you joining us here on what has been perhaps the most bizarre story of this evening, in which is a PIL being filed and notices being issued by the Gujarat High Court in a matter that involves the game Pokemon.